Hi, Assalamualaikum. Welcome back to Family Law course. We have come to the last topic under this course, which is parent and children. This topic consists of two subtopics, guardianship and custody, and legitimacy. At the end of this topic, students will be able to explain the rights of children, identify the duty of parents or guardian over the children, and apply the relevant appropriate laws relating to rights of children into a real situation. I will start with the discussion on the first part, which is divided into two, guardianship and custody. For the purpose of discussion on guardianship and custody, we will be referring to two statutes, Law Reform Marriage and Divorce Act 1976 and Guardianship of Infants Act 1961. Before we move on to these subtopics, we need to first define the word child. Section 2 of the LRA defines child of the marriage as a child of both parties to the marriage in question, or a child of one party to the marriage accepted as one of the family by the other party, and child in this context includes an illegitimate child of and a child adopted by either of the parties to the marriage in pursuance of an adoption order made under any written law relating to adoption. On the other hand, the Married Women and Children Maintenance Act 1950 makes no provision for the meaning of child. It only confers rights to both legitimate and illegitimate children to claim for maintenance from the biological father. Section 87 stated that wherever the context so requires, child has the meaning of child of the marriage as defined in Section 2, who is under the age of 18 years. Perhaps you are wondering what is the difference between guardianship and custody. It can be quite confusing since custody is part of guardianship, but guardianship does not consist of custody wholly. In other words, anyone who has custody over a child is a guardian, but not all guardians has custody. Guardianship has been defined as the right and duty of protecting the person and property of a minor. Basically, a guardian is a person who has power over a child's upbringing, care, discipline, and religion. This is because a minor has no legal capacity to protect his own interests or manage his affairs, thus guardian is necessary. For example, the guardian can enter into contract on a minor's behalf. So how do we differentiate between guardianship and custody? One simple example would be in the situation where a father may be the guardian, but the mother may have the custody. Here, the father may have a say in the child's upbringing, but the mother physically has the child living with her. For the topic of guardianship, it is further divided into two, guardian of person of minor and guardian of property of a minor. With regard to guardian of person of minor, Section 2, Subsection 1 of the Guardianship of Infants Act 1961 defines infant as a person who has not attained his majority. The guardian is responsible for support, health, and education as has been provided under Section 3 of Guardianship of Infants Act 1961. Whereas for guardian of property of minor, Section 4 of the Guardianship of Infants Act 1961 provides that a guardian of the property of an infant shall have the control and management of the infant's property and shall deal therewith as carefully as a man of ordinary prudence would deal with his own property and may, subject to this act, do all acts which are reasonable and proper for the realization or protection of the infant's property. For this regard, the parents, which are the father and the mother, of a minor has equal rights to the person and property of the minor as stated under Section 5, Subsection 1 of the Guardianship of Infants Act 1961. Now moving on to our next term, which is custody. There is no exact definition of custody in the LRA. Basically, custody is defined as the right to look after a child's welfare and take care of the child physically. The definition of child is spelled out under Section 87 and 2 of the Law Reform Marriage and Divorce Act 1976, which means person below 18, child of marriage of both parties or of one party and accepted by the other, illegitimate child or adopted child. With regard to custody of the children of the marriage, Section 88 of the LRA give the court power to order custody. Okay.
3, 2, 1.
Okay.
Yeah, ready? 3, 2, 1, okay.
Moving on to our next term, which is custody. There is no exact definition of custody in the LRE. Basically, custody is defined as the right to look after a child's welfare and take care of the child physically.
Sekejap. Is that the back satu slide?
Oh, okay. Patutlah, tak tukar.
Okay, ready? 3, 2, 1, okay.
Moving on to our next term, which is custody. There is no exact definition of custody in the LRE. Basically, custody is defined as the right to look after a child's welfare and take care of the child physically. The definition of child is spelled out under sections 87 and 2 of the Law Reform Marriage and Divorce Act 1976, which means person below 18, child of marriage of both parties or of one party and accepted by the other, illegitimate child or adopted child. Section 88 of the LRA gives the court power to order custody by making order to place a child in the custody of his or her father or his or her mother, or where there are exceptional circumstances making it undesirable that the child be entrusted to either parent, of any other relative of the child, or of any association the objects of which include child welfare, or to any other suitable person. Now, how does the court decide the most suitable person to be given custody? Section 88, subsection 2 stated that the paramount consideration in deciding whose custody a child should be placed shall be the welfare of the child. And subject to this, the court shall have regard to the wishes of the parents of the child and to the wishes of the child where he or she is of an age to express an independent opinion. Do take note that under this section, the welfare of the child is regarded as the most important factor to be considered. Subsection 3 of the same section stated that there shall be a rebuttable presumption that is for the good of a child below the age of 7 years to be with his or her mother. But in deciding whether that presumption applies to the facts of any particular case, the court shall have regard to the undesirability of disturbing the life of a child by changes of custody. For example, if one parent, which is the father, already have custody over the child, and applying the presumption by giving custody to the mother would disturb the life of the child. Where there are 2 or more children of a marriage, the court shall not be bound to place both or all in the custody of the same person, but shall consider the welfare of each independently as had been provided under subsection 4 of section 88 of the LRE. Among the factors that will be considered by the court in determining the welfare of the infant are age and sex of the infant, education and religion of the infant, material advantages for infant, racial and cultural background, customs, medical needs, conduct of parties, and wishes of the parties. And that ends part 1 of guardianship and custody.